going to preside in this, and I'm the director of the Bonavera Institute, which hosts the Moot. My two co-judges are Judge Mark Stevens and Judge Nani Jensen-Raventlow. A very warm welcome to them. They're long-standing supporters of the Moot, and it's very nice to have them. This is always a very entertaining occasion for judges and an interesting occasion to hear the outstanding oralists of this Moot. So we're now going to turn to our bailiff, who will manage the time for us as we turn to the applicants' submissions. Alistair.
The Universal Freedom of Expression Court is now in session. Honourable Judges Nani Jansen and Mark Stevens presiding, with Judge Cato Reagan as President of the Court. The current matter before the court is the case between Swarna Shikra and Kanthi Bezra as applicants against Kuralu as respondent. Each side has 30 minutes to present their case, and first counsel for the applicants is requested to come forward.
Yeah. May it please the Honourable Court, I am Kieran Bailey, and I appeared together with Caitlin Farrell on behalf of the applicants Shikra and Bezra. I will be speaking for 16 minutes and Ms. Farrell for 14. I'm going to address firstly why it is that the state of Kuralu has failed to impose a statutory duty to remove content likely to cause imminent harm of a serious nature, and this violated Shikra and Bezra's rights. And then I will go into why the investigation into the break-in was not effective. The form of my first submission will first address the burden we have to prove that there's a violation. Secondly, the state's burden that it has failed to uphold rights under the covenant. And thirdly, why a statutory obligation would meet the tests of provided by law and necessity. And then my submission on the investigation will deal firstly with why the warrant was not issued, and that was ineffective. And finally, I will address the balance of rights. So dealing with the first submission, the burden is, I accept, on the applicants to show that there was a violation by the message. If we construe the message that was posted on Chirp by Barn Owl Nuksu, which is "What a pair of bird brains trash their nests," I suggest this does violate 17 and 19 rights because it calls for violence. The language is imperative. It's asking for an attack to take place. Trashing is a term invoking violence. The context of this message was a raucous debate about universities, and it followed on from a message by another user calling Shikra and Bezra evil neoliberals. So the context of the message was a personal attack, and it violates 17 because it's calling for an attack on privacy and the home because it's inciting violence, and violates freedom of expression in Shikra and Bezra's case because there is a chilling effect on one's freedom of expression if other people are inciting violence towards you based on your opinions.
But Mr. Bailey, go ahead, Judge Stevens.
Thank you. What are we to take as our test here? Are you saying that there's some legal principle, or are we looking at Clause 8 of Chirp's community guidelines? Because I note in the community guidelines, it talks about credible threats. And for myself, I would want to be persuaded that this was a credible threat, not with the benefit of hindsight, but with the benefit of when it was posted.
Yeah, well, Your Excellency, there is a legal test. The legal test is so to violate an Article 17 right, so privacy, you need to have a lawful interference, and it cannot be arbitrary. And for 19, to interfere with expression, it needs to be provided by law and necessary. And if you apply the European Court's test, necessary in a democratic society. So that's the legal approach. I mean, if you wanted to take the Brandenburg and Ohio test, which is imminent violence, that's the American Supreme Court case from 1969, calling for imminent violence. And that, I suggest, is what Chirp's guidelines are dealing with, credible threats, imminence.
Yeah, but in that case, that all feeds into necessity. And so isn't the starting point here that you have to persuade us that this was a credible threat?
Well, that can be the starting point. It has to be a threat which violates the rights. So it has to be a threat of imminent harm. So credible threat of imminent harm. And the reason I say that it is because it's calling for trash their nests. I suggest that is violent language in the context of the bird brain word which precedes it. Birds have nests. It's calling for trashing the home of the first person referred to. And the bird brains, of course, refers to Shikra and Bezra. And we know that because the comment by Barnell Nuksu follows on from Red Kite's message.
Why is this not? Why are we to take this as a credible threat rather than mere hyperbole? There's no address. There's no individuals identified, albeit that you're trying to persuade me they are identifiable. So I'm having some struggle, and at the moment, with whether this was a credible threat. I noticed that nobody reported it. I don't know what you think I should make of that, but at the moment, that also indicates to me that there was little anticipation of violence.
Your Excellency, there are 2 points I would make in response to that. The first is, in terms of the credible nature of this threat, if you took the Rabat Plan of Action principles, I know that deals with Article 20, but the principles can be relevant for construing hate speech. If we think about the context here, the context is messages on the internet attacking Shikra and Bezra personally. The previous message was about them. The bird brains, this message definitely refers to them. Then the comment, trash their nests. It is a metaphor, I accept, but even a metaphor, unless the metaphor is very sophisticated and unclear, you can read the metaphor to see what is the objective intent, what's the purpose, what's it trying to do. And my submission is that by saying trash their nests with respect to the birds being Shikra and Bezra, that is not hyperbole. Hyperbole would be to say, down with Shikra and Bezra, down with their campaign, push back, that could be hyperbole. But to say trash their nests has no alternative construction than undertake some act of violence. It's calling for action.
Okay.
I'll move on to the statutory obligation point. The state is in violation by not having a statutory obligation. Now, my learned friends point to, well, firstly, states, as we know, as the Honourable Court knows, states have to uphold rights under Article 2.3. It's a duty. My learned friends in their memorial referred to the Sunday Times and United Kingdom case, number 1, European Court, which says that case law can be an appropriate means of upholding rights. And they appear to suggest that the case of Batichicha, 2016, which extends constitutional rights to social media providers and people using it, the 23 million people using it, is sufficient. My submission is that this is not sufficient, and the statutory tests and the case law are markedly different here. In Sunday Times, and also to give you another example, Cruslan in France, 1990, which is the same test as Sunday Times, that case law can be effective. Both of those cases addressed very specific points of law. Sunday Times was contempt of court, so a creature of the court system, and Cruslan addressed phone tapping. Batichicha does not have a specific test. So we are not, by Batichicha, upholding the principle of legal certainty or an accessible and foreseeable duty, because all Batichicha does is extend the Constitution. And it's the same as with any government. You don't just have a constitution and then say, it's now up to the courts, we're moving on. You have to have laws in place to deal with specific issues. That's the way you maintain the principle of certainty. There is no certainty under Batichicha, except to the extent of its factual matrix, so releasing addresses on the internet. And the way the common law would develop here is incrementally, case by case. And of course, in Sunday Times and Cruslan, there was a wealth of authority going back decades to show an incremental development of a right. But in this case, there is no coherent body of case law. There's just one case saying constitutional rights extend, and it doesn't say what happens in each case. So that's why we need a statute. The statute is also necessary because the Supreme Court in Shikra and Bezra's case in 2022 said the time has come for the state to seriously consider legislation. So essentially, the courts have kicked the issue to the legislature. The courts are not going to impose a duty specifically about social media. That could be for a whole range of reasons. The one which appears to be the case from their judgment is they don't want to deal with issues of legislative policy. And that's another reason why statute is important here, because social media, as we know, is a fast-moving target. It's new, it's very expansive, and it may require a specific legislative provision to provide a complete framework. To use the words of the European Court in Sunday Times, a substantial enactment to provide for the upholding of rights. And I submit that the petition does not do that, nor actually does the only law in Karulu which would be relevant here, which is the Penal Act, Section 38, which prohibits incitement of violence on racial and ethnic grounds, so applying Article 20 of the Covenant. That does not go far enough either, because that only deals with ethnic and religious hatred, not other forms of harm, which can still lead to violence.
Mr. Bailey, could you just characterize the nature of the positive duty here? What is the precise framework of the positive duty which you suggest the statute would respond to?
Yeah, Madam President, the statutory duty would respond to the duty under Article 2.3 to uphold rights under the Covenant. And this is specifically, I suggest, with respect to privacy, so 17, and free expression, 19. And for the reasons I gave you earlier, those are violated by imminent harm on the internet, because for one thing, it spreads so quickly. And in doing so, it can call for violence that offends privacy, it offends privacy in the home, and it can have a chilling effect on freedom of speech. And you will be aware of the case of Dink and Turkey, which says that the European Court case in 2020, which says that the state has to uphold a framework online for free dialogue. And you can't have that if when you say something, someone's going online saying, go and abuse this person. So that's what the duty responds to, 17 and 19 being upheld. And it would be necessary to have this for the reasons given. But I'm going to move on to the issue of the investigation, if that's all right. The investigation was not effective. For the investigation to be effective, if we take the test from Ismailova, Kriskaiva, and Belarus 2012, or if we take El Hassi and Libya 2007, both European Court cases. Sorry, the second is European Court, the first is Human Rights Committee. These cases suggest clearly that for an investigation to be effective, it has to pursue clear leads and be capable of bringing the culprits to justice. That's the test under international law. And within the test itself from Karulu's own statutory law, there needs to be reasonable suspicion to issue a warrant. That's the Criminal Procedure Act, Section 215. Now, there certainly was reasonable suspicion here to pursue a clear lead. The word bird brain, which was sprayed on the house, was the word in the message. There's a temporal link. The attack happens a mere number of hours after the chirp message inciting violence is posted. And so the attack itself certainly has some link to that post. The word bird brains is very specific. This is not a usual word used in vandalism. And it's not necessarily the barn owl person who has done the attack or coordinated the attack, but they may have information about who has committed the attack. And that is the test that Your Excellencies need to think about, is would pursuing this lead to more information to provide a remedy, the remedy being bringing the people that vandalized the home to justice. And if I deal finally with the issue of balancing rights here, the House of Lords case of Campbell and MGM.
Bailey, just to push you on this proposition that Barn Owl would have some information about who may have perpetrated the attack. Why would you say that? At the end of the day, what we know that Barn Owl has done is made a public statement on a social media platform and may have absolutely no idea who read it, who thought about it, who discussed it. Why is that a basis for the issue of a warrant?
Your Excellency, the reason that's a basis is because I suggest there is reasonable suspicion. It may not be overwhelming suspicion, but it's reasonable to suggest that when the message used this specific word bird brains and called for violence, trash their nest, and then a mere number of hours later, the home is ransacked and the word bird brains is spray painted over the walls, that suggests a link between the message and what later transpired.
But it doesn't suggest it doesn't provide any basis for assuming that Barn Owl will know who picked up their message.
Well, they may have been involved somehow in the attack, or they may have knowledge if somebody messaged them privately on.
Well, you're just fishing here. I mean, why isn't you making an application to see who actually engaged with the post? Because that might give you an intervening step. But I think it's a bit of a stretch to say just because the lexicon is the same that it must be the same person.
Well, Your Excellency, if you're thinking about the lexicon here, the issue I'm assuming you have in mind is anonymity online and the fact that people might read it. If we take the recent European court case standard Wahl Gesellschaft MBV in Austria number 3 2021, the test is anonymity is important but not an absolute. And if I think there's an echo here. If revealing the information will lead to justice being pursued, then we can unveil that person's anonymity. So you need strong reasons. This court needs strong reasons to overturn the decision of the magistrate in the Supreme Court. But the reason I'm saying you can is because the right of the user to anonymity is outweighed by the need to find justice. And the phrase itself in the message links to what happened. There's a temporal link, there's a word link, and there's an action link. Action being trash their nest, and the nest of the birds was trashed. So that's reasonable suspicion, I submit.
Thank you, Mr. Bailey. I think your time is now up. Thanks very much for your submissions. We'll turn to Ms. Farrell.
Good morning, Excellency. So, apologies about that, Your Excellencies. Can I check that I can now be heard without an echo? Could I also just check that all non-speaking participants in the Zoom meeting are on mute?
Yes.
Perfect. Thank you very much. Good morning. If it pleases the Honourable Court, my name is Caitlin Farrell and I appear for the applicants Swana Shikra and Kanthi Brezra alongside my learned co-counsel Kieran Bailey. I will be speaking for a time of 14 minutes on issue B, which pertains to the state of Kerala's violation of Shikra's right to expression under Article 19 of the ICCPR, an article which Kerala have ratified. It is the applicant's case that the suspension of Shikra and the subsequent requirements that she sign a written undertaking confirming she will refrain from making similar statements from that which she made on the 9th of July is an infringement on her right to freedom of expression, and that such an infringement is not qualified under paragraph 3 of Article 19, which requires that restrictions on freedom of expression must be provided by law, pursuant to one of the legitimate aims specified in paragraphs 3A and 3B of that article, and necessary and proportionate to achieve the legitimate aim specified. Now, it is the burden of the state to prove that they have met all 3 of those conditions. It is not the burden of the applicant. With this in mind, I'll be focusing my submissions on the question of whether the restriction was necessary and proportionate, and secondly, the question of whether it was provided by law. With regard to the question of whether this was in pursuit of a legitimate aim, as you will have seen by my memorial, it is our submission that it was not, but I will redirect you to my memorial for those submissions. Firstly then, it is the submission of the applicant that the state of Kerala's action was not necessary or proportionate in a democratic society. I shall be dealing with the question of necessity first. Now, as per General Comment 34 on Article 19, necessity means that there should be a pressing social need for the restriction. The party invoking the restriction, so in this case, the state of Kerala, must show there is a direct and immediate connection between the expression and the protected interest. Now, on this point, I've had the privilege of reading the state's memorial prior to the hearing, and I must submit that they did not make any submissions on whether there would be an immediate and direct connection, and thus I am unfortunately unable to respond on that point. However, I will nevertheless be continuing submissions to say that there was not a direct and immediate connection. On this point, the appellant does not dispute that the education of students is a protected interest. What we do argue is that simply there was not a direct and immediate link between Shikra's post on Chirp and a threat to that interest. Whilst it is permissible to restrict forms of expression that constitute intimidation or coercion, Shikra's expression encouraged political protest rather than coercing others into protesting. Firstly, Shikra did not force any individual to participate in the process. The use of refuse to teach or attend classes, occupy all university premises, these were invitations rather than coercions. Secondly, simply a direct and immediate connection between Shikra's post and the protest that followed cannot be established. SANUC members boycotting classes on the 10th of July were likely responding to the post by SANUC. It is unclear that any would have boycotted classes but for SANUC's post rather than Shikra's. Union members are obligated to follow the instructions of their unions. Shikra had no such powers of obligation on her followers. Thirdly, strong language.
Can I just take you back, Ms. Farrell? You talked about an invitation versus coercion. What if we think it's an exhortation?
Could I clarify what exactly you mean by exhortation?
Well, yes, I mean, I'm saying, is this something which we would exhort somebody to do? Are we actually dealing with a situation here where there is encouragement, if you will, the sort of situations that we saw in Rwanda through Radio Mille Collines?
Firstly, I would say the facts are distinguished from the Rwanda example, though I appreciate how the analogy could work for the use of establishing a difference between coercion and encouragement. And secondly, I submit that here, Shikra undoubtedly is encouraging people to boycott classes. That is not disputed. However, what is needed to show that this is a necessary and proportionate response is saying that this is a direct and immediate link. Encouraging protest is protected under ICCPR Article 8. Thank you. I shall proceed with my submissions then. Strong language does not incite lawless action, which does not incite lawless action cannot be restricted. Shikra's language, such as traitors, is still regarded as protected speech. As we've seen in NAACP and Claiborne Hardware Co. from the US Supreme Court, and more recently, the Oversight Board at Meta with regard to the pro-Navalny protests in Russia, political rhetoric is undoubtedly going to be spirited, such as the language that Shikra is using here. And thus, I reject any claims by the state that Shikra's language was inciting violence in any way. Indeed, if we look at the case of Civet and Belarus, which is a European Court of Human Rights case, there encouraging voters to boycott an election was again protected speech by Article 19, and any restriction on it was simply not necessary to meet the pressing social need.
Ms. Farrell, the distinctive characteristic of this case is that Ms. Shikra is in an employment relationship with the university, which needs to be able to ensure that its classes run, properly and in an orderly manner in relation to students. Students have a right to education after all. Does that not influence the question of whether the limitation on her freedom of expression is necessary and appropriate in these circumstances, given the university's need to ensure that freedom of education is not interrupted?
Thank you, Your Excellency. On that, I have two submissions. Firstly, yes, we absolutely should pay attention to Shikra's position here as a tenured professor. However, as outlined in General Comment 34 on Article 19, for individuals who occupy positions of public interest and high profiles, in those cases, their freedom of speech actually should be especially protected because of the influence their speech has, but also because of the risk that restricting their speech can have on them is far higher than restricting the speech of an individual who is not in the public eye. And secondly, regarding the right to education, absolutely, Your Excellencies, it is the university's mission to ensure the right to education. However, it is our submission that the restrictions here do not fulfill that protective function. And indeed, this is the submission I was about to come on to regarding proportionality. The state cannot say here that these restrictions are aiming to protect the right to education because, in fact, they're threatening it. By restricting the speech of an academic, you're creating a chilling environment in the university context. We're not just restricting the speech of Shikra here, but we're sending a message to her fellow academics that they too could potentially have their speech restricted. We're sending a message to students that certain forms of speech are not restricted.
No, the purpose of the guidelines under Section 24 of the Academic Code are to prevent the disruption of scheduled or normal activities, which for a university is education. I cannot see why that, why saying to Professor Shikra that she may not call for the disruption of educational classes is not disproportionate, or is disproportionate, is not a proportionate limitation given the university's duty, positive duty, to provide education. We're here in a situation of balancing rights, aren't we?
Absolutely, Your Excellencies, you took the words straight out of my mouth. This is a situation of balancing rights. And it is our submission that Shikra's right to freedom of expression is a right that needs to be balanced against the student's right to education. But considering that the restriction on Shikra's right to freedom of expression is not just a restriction on Shikra, but a restriction on her fellow academics, and indeed a restriction on students by creating a chilling environment, this is not just a matter of comparing Shikra's post with the education of the university student body, because actually restricting Shikra's freedom of expression affects the learning environment of the student body, and thus actually brings the right to education into jeopardy. This is not a suitable...
Seems to me the reverse is true. Preventing academics can express their views on relation to private education in a myriad of ways. But once they start using their freedom of expression to call for disruption of education activities, that's the moment that they cause an impairment of the freedom of education. And they could do it in many other ways. Students are in an entirely different situation. Here we're talking about the right of academics. Why is it disproportionate to say to academics, you can say whatever you like about private education, but what you may not do is call for the disruption of classes to which students have a constitutional right or international human right?
Simply because, Your Excellency, that was not the case here. The state did not say to Shikra, you can say whatever you want about the privatization of education. They asked her to put a written undertaking saying that she would refrain from making similar statements in the future. Now, similar statements is a very vague term. I dare say the state will argue that this is absolutely confined to social media and making statements about disruption. However, similar statements could easily then become applicable to speaking entirely on the privatization of education. In that sense, then, this is not just saying to Shikra, do not disrupt the student body, which she is well within her ICCPR Article 8 right to do, but actually it's saying, do not speak about this at all, which undoubtedly restricts her freedom of expression and is disproportionate to the action she did. With the amount of time I have left in mind, I shall now be moving on to my second submission, that the state of Curley's action was unlawful. Now, as established in General Comment 34, and as we have also seen from Adriana Beatrix Gallo in Argentina, which is an inter-American human rights case, for a restriction to be lawful, it must be prescribed by domestic law that is sufficiently narrow and precise. Now, Shikra's suspension was prompted, as Your Excellency has pointed out, by Section 24, Paragraph 4 of the Academic Code of Conduct, which talks about disciplinary action. It does not mention the disciplinary action that could follow. So one wonders how Shikra was ever supposed to foresee what disciplinary action could amount from her actions. And it also states that actions include but are not limited to the following. It then goes on to talk about disruption, riot, terms which have no statutory definition. Undoubtedly, then, this legislation is both imprecise and overbroad, potentially, as I've previously submitted, constituting a ban on any kind of strike action, which is protected under ICCPR Article 8. Legislation which is drafted in too generic terms simply does not satisfy the test for legality, as it allows for unfettered discretion. In this regard, the restrictions placed on Shikra were not provided by law. Now, unless Your Excellencies have questions about that submission, I see I have time, so we'll indeed...
Would there not be an obligation to interpret Section 24 consistently with other rights that are protected, so that you could read the language of causing nuisance or disruption not to be relating to lawful strike action?
I fail to see how it could be read as to not including strike action as violating the academic code of conduct. Disrupting the normal operations, that is what peaceful assembly is. And so strike action plainly does come under it. And the fact that it allows for unfettered discretion means that if the university so wished to, they could indeed prosecute an example of strike action under that code.
But what I'm saying is you could say inciting others to cause nuisance or disrupt scheduled or normal activities would not extend to lawful strike action.
Well,
in that way, which would be the kind of principle of legality, the idea that you would interpret a provision consistently with rights.
Indeed, Your Excellency, I see how that phrase could be construed to permit strike action. However, the phrase that precedes it about disrupting the normal operations of the university, which falls before the word or, thus suggesting there's two separate clauses here that action could fall into. Strike action absolutely could fall into that. And I understand Your Excellency's point about the importance of interpreting this law with rights. However, one wonders how, bearing in mind they have used the law to justify a restriction on Shikha's freedom of expression, which the applicant holds was unjustified, it does not seem to me that they are interpreting that law in line with rights. Thank you, Your Excellency. As previously established at the beginning of my speech, if Your Excellencies have any questions about legitimacy or indeed public order, we hold that although the right to education is a legitimate reason to do a restriction, public order here was simply not threatened, given that this is a university environment which ought to promote free speech. Please do refer to my memorial. But on that point, that concludes my submissions. Thank you very much, Your Excellencies.
Thank you very much, Ms. Farrell. We will now turn to the respondents, Team 707.
Your Excellencies, before I begin my submissions, may I confirm that I can be both seen and heard by the bench?
Thank you, Mr. Santamaria. Yes, we can hear you well and see you.
Thank you. Madam President, Your Excellencies, good day, and may it please this honorable court. My name is Brian Santamaria, respectfully appearing as first counsel for the respondent state of Curulu. With me are my co-counsel, Ms. Meg Arbo, and our off-counsel, Ms. Celine Dael. For the first 16 minutes, Your Excellencies, I will address this court on the first issue of this case, concerning the obligations of Curulu to protect and give effect to the rights to privacy and freedom of expression, as well as to provide an effective remedy should these rights be violated. For the succeeding 14 minutes, my co-counsel, Ms. Arbo, shall discuss the second issue, concerning Shwarna Shikra's suspension from the National University of Curulu. We reserve 3 minutes for our rebuttal. Unless there are any preliminary questions, Your Excellencies, I shall now begin my submissions. Thank you, Madam President. Thank you, Madam President, Your Excellencies, and may it please this honorable court. As a state party to the ICCPR, Curulu has an obligation to protect and give effect to privacy and freedom of expression. Moreover, Your Excellencies, when these rights are violated, Curulu must ensure that there is an effective remedy in place. The applicants now come before this honorable court and claim that Curulu had breached these very obligations. First, they claim that there is a lack of statutory duty in Curulu, and this leads to a violation of its obligations under the covenant. Second, they claim that the investigation conducted by Curulu into the break-in and vandalization of the applicant's home was not effective. Your Excellencies, we cannot agree with these contentions. As our submissions shall demonstrate, Curulu did nothing but comply and fulfill its obligations under the ICCPR. We shall first begin by discussing the supposed need to impose a statutory duty on social media service providers. The applicants make two general points under the submission, Your Excellencies, which we address in turn. First, the applicants cannot claim that their rights had been violated on Chirp by the comment made by Barn al-Nuksu as well as other anonymous commenters. We appreciate the applicant's citation of the UN Rabat Plan of Action, which has indeed been used to evaluate if any expression amounts to an incitement to hatred or violence. What we disagree with, Your Excellencies, is how the applicants have applied the Rabat Plan of Action in the present case. For example, Your Excellencies, by examining the factor of context, we can see clearly how Barn al-Nuksu's comments here do not reach the threshold of incitement. Even the applicant claimed that the comments were made within the context of a debate, which is a matter of great public importance. Specifically, Your Excellencies, the comments were made in relation to the public education crisis currently going on in Kurulu. And while we do recognize that the comments may have been disturbing or perhaps shocking in their wording, this does not make them reach the level of hate speech or incitement to violence.
But
This
Mr.
was
Santa Maria, the three words trash their nests seems to me to be very close to incitement. It's clearly a reference to a home, they're referred to as bird brains. This is a home, and it is suggesting that there should be damage or destruction wreaked on their homes. If the post had stopped after bird brains, that would have been a very different matter. But this does seem to me to be very close to incitement. Would you not agree?
We do understand your concern, Madam President, but in this regard, we respectfully disagree. Allow us to cite for this court the case of Terentiev versus Russia, decided by the European Court of Human Rights. In that case, Your Excellencies, the European Court noted that even those expressions may use shocking, offensive, or even disturbing terms, this does not mean they are hate speech if they are made within the context of a political matter. In the case of Terentiev, Your Excellencies, the expression called to burn infidels just like at Auschwitz. But despite this, it was made within a political context, and we submit that a similar analysis obtains in the present case. Although Barn al-Nuksu's call to trash the applicant's nest may indeed be disturbing and shocking with regard to their content and form, the political context still reveals that his intention was not to incite violence against the applicants, but rather to display through hyperbole and emotion their disagreement with Swarna-Shikha's stance.
I could have understood that submission, Mr. Santa Maria, if we were talking about an unspecified group of persons. But here we're talking about a specific individual who will have a specific home. And the language seems to be quite different then. If it's just general burn all infidels, that's a different matter. But here we're talking about a particular person, Professor Shikra and her partner. And they are named in the previous posts. It's not, there's no abstract character to who these individuals are. And that seems to me to take it out of this similarity to the case you're citing.
We do understand your concern, Your Excellencies, but do allow us to argue as well that just because these comments referred to the applicants, it does not necessarily mean that they are still hate speech or incitement to violence. In the European Court of Human Rights case of Tamiz versus the United Kingdoms, this case also involved comments that pertain to a specific individual. But the European Court noted that although the language used by the comments may have been vulgar or disturbing, this is only expected from interactions online, Your Excellencies. Just because the comments may be vulgar, it does not necessarily mean that it is still hate speech or incitement to violence. Given this, we submit.
So let's just take this particular example. Your proposition is that trash the nest, the very specific nest, isn't sufficient. Obviously, this is a scale. What would have been sufficient in this situation?
Well, Your Excellencies, a sufficient expression that would qualify as incitement to violence would be if something like in Batitia had happened, if the comment had revealed the homes of the applicants, then that would have indeed amounted to an incitement to violence that could be validly restricted. But here, Your Excellencies, we submit by the use of metaphorical language, we can see that Barn al-Nuksu is merely disagreeing or expressing his frustration with the stance of the applicants. Thank you, Your Excellencies. Given this, the applicants have no basis to say that their rights had been violated by the comments made by the anonymous users. The second point that the applicants make under the statutory duty issue, Your Excellencies, is that there is a need to impose or enact legislation which is a burden of the state. We do not dispute this, Your Excellencies. After all, we recognize that Article 2, Paragraph 2 of the ICCPR provides a positive obligation for states to take the necessary steps to adopt legislative or other measures in order to protect and give effect to covenant rights. However, Your Excellencies, we note that this obligation is only conditional. As the first phrase of Article 2, Paragraph 2 clearly provides, this obligation is only engaged when there are no existing measures already in place. Your Excellencies, a more than cursory examination of the facts tells us that Karulu already employs an effective legislative framework that sufficiently protects and guarantees the right to privacy and freedom of expression in the online sphere. This can be seen from the Constitution of Karulu, which already protects privacy and freedom of expression through Article 7 and 9 respectively. Moreover, Your Excellencies, these constitutional provisions had been invoked by the Constitutional Court in order to hold a social media service provider liable for online harmful content. We are referring to the case of Baticha versus the state of Karulu. Simply put, Your Excellencies, as a result of the Baticha ruling, if any social media service provider fails to observe its special duties and obligations under Karulu's constitution, then they may be held liable. At this point in time, I would like to make reference to the applicant's claim that Baticha is not sufficient because it does not lay down any specific standard that social media platforms must follow. This is a misrepresentation of the facts, Your Excellencies. Paragraph 35 clearly tells us, and if you are with me, Paragraph 35 tells us that the standard employed in Baticha is to determine whether social media service providers have enacted reasonable steps in order to address online harmful content. We submit, Your Excellencies, that these reasonable steps already constitute sufficient guidance that social media platforms must observe in order to ensure that they do not violate Karulu's constitution. In fact, Your Excellencies, as paragraph 36 of the record tells us, it was because of the Baticha ruling that Chirp developed its AI mechanism and made it more effective in detecting harmful content. Given all of this, Your Excellencies,
is the framework of reasonable guidelines really satisfactory for clarifying what rights and obligations are at play here? Aren't both social media platforms and users of social media platforms entitled to have greater clarity about what is required of social media platforms? And isn't that an obligation that rests on the state under Article 2?
Certainly, Madam President, we don't disagree with that point. But we do note that reasonable guidelines are indeed a sufficient standard for the purposes of regulating online content. For example, Your Excellencies, Section 46 of Australia's Online Safety Act uses the same standard, that is, reasonable steps that social media platforms must take. And in a commentary on that law, Australia's e-safety commissioner noted that the use of reasonable suspicion is one by design. It accounts for flexibility, Your Excellencies, and as well as reasonability. This is because what is reasonable for one social media platform may not be reasonable for another. By using reasonable steps as a standard, we can already account for the different natures and capabilities of social media platforms. Thus, Your Excellencies, we submit that there is indeed no need for Karulu here to enact legislation. Having addressed this issue, we now proceed to the second sub-issue concerning the investigation conducted by the COA Central Police. We appreciate the applicant's citation of the European Court of Human Rights case of Ismailova versus Azerbaijan. However, Your Excellencies, the applicants have misunderstood the point of the European Court in that case. In that case, the court noted that the standard that the state must observe is one of due diligence. This is because, Your Excellencies, the conduct of an effective investigation is an obligation not of results, but one of means. Indeed, the European Court noted in Ismailova that this obligation does not mean that the state must guarantee a favorable outcome to the applicants. In the present case, Your Excellencies, we submit that there was indeed due diligence in the investigation conducted by Curulu's police force. We can see this clearly from paragraphs 52 to 56 of the record. If Your Excellencies are with me, we can see that the break-in and vandalization had occurred on July 10. And yet, not even 3 days later, the COA Central Police had already contacted a representative from CHIRP and had also applied for a warrant before before the COA Central Magistrate, rather. And despite the denial of this warrant, the COA Central Police continues to investigate the crime by examining CCTV footage and other forensic evidence. Your Excellencies, these facts demonstrate that the police had observed due diligence in the conduct of their investigation. The applicants therefore have no basis to say that the investigation was ineffective. More than that, Your Excellencies, the applicants insist, though, that the state should have granted the warrant that would reveal Barnalnuxu's comments. However, we cannot agree with this proposal. This is because Barnalnuxu's comments were made under the guise of anonymous expression. Anonymous expression has been recognized in the 2015 Special Rapporteur report by the United Nations Special Rapporteur David Kay as being an enabler for the free flow of ideas, especially online. Accordingly, Your Excellencies, any interference with anonymous expression must comply with the strict and cumulative standards under the TREAT test. So strong is anonymous expression, Your Excellencies, that the European Court of Human Rights, in the case of Standard Verlagsgesellschaft MBH versus Austria, ultimately upheld anonymous expression, even though the court observed there that anonymous expression is not absolute, given that the anonymous expression was made within the context of political matters, then there could be no interference with this right. We submit, Your Excellencies, that this
Not even if there's an imminent harm being occurred?
Your Excellencies, in that case, then it would be all right to breach interference because it would it would be all right to interfere with privacy or anonymous expression because it would pursue a legitimate aim. But we submit here, Your Excellencies, that in the present case, there is no imminent harm from Barnalnuxu's comments. We note that the applicants cite only the fact that both the comments as well as the vandalism use the same word, which is bird brains. However, Your Excellencies, this is not enough to justify the issuance of a warrant. The United Nations Special Rapporteur in his 2015 report noted that any interference on anonymous expression must demonstrate strong and sufficient evidence. Quite clearly, the applicant's reliance on circumstantial and speculative evidence does not satisfy this threshold. Justice. But justice cannot come, must not come at the price of privacy or free expression of others. Your Excellencies, I see that my time is up. Unless I may be of any further assistance in this court, I now see the podium to my co-counsel. Thank you, Madam President, Your Excellencies, and may it please the Honorable Court.
Thank you, Mr. Santamaria. Ms. Arbo.
Madam President, Your Excellencies, before I begin, may I confirm if I am both audible and visible to the court? Thank you, Your Excellencies. Madam President, Your Excellencies, good day, and may it please the court. My name is Meg Arbo, the second counsel for the respondent, the state of Curulu. I will be speaking for 14 minutes on our second submission that the respondent's action with respect to the suspension of Shikra and the imposing of conditions on the lifting of her suspension did not if Your Excellency.
Yes, thank you, Ms.
Thank you,
Arbo.
Madam President. And may it please the court. The state of Curulu is committed in ensuring the protection of freedom of expression of its citizens, but it also recognizes its duty to balance this right with equally important rights and the broad interests of society. In the present case, the applicant Shikra, a highly regarded professor at the National University of Kurulu with over 200,000 followers on Chirp, posted on her public account a statement that operated not as a mere expression of her support in the privatization of education, but as incitement to disrupt public order and interfere with the rights of others. We begin by respectfully directing this honorable court's attention to paragraph 37 of the record. If your excellencies are with me at paragraph 37, we can see that the applicant's statement called for both students and teachers to do three things until change comes. First is to refuse to teach or attend classes. Second is to occupy all university premises. And third is to not tolerate traitors to the cause. Allow us to guide this honorable court in ruling that the disciplinary action imposed on Professor Shikra is justified, as such restriction passes the three-part test under paragraph 3 of Article 19 of the ICCPR, which includes first, that the restriction is provided by law, second, that it pursues legitimate aims, and third, it is necessary and proportionate. To address the applicant's claims in turn, we will first discuss the second and third part of the three-part test. Your Excellencies, we submit that the restriction is necessary to pursue legitimate aims, particularly first, the protection of public order, and second, the respect of the right to education. Your Excellencies, contrary to the applicant's submission, it is our position that there is a pressing social need to protect public order, and we will illustrate this by examining Professor Shikra's statement based on the Rabat Plan of Action, which we will present on two levels. First is based on the applicant's status as the speaker, and second is on the context of her statement and its likelihood to harm. On the first level, Your Excellencies, here we emphasize that Professor Shikra is not only a highly regarded professor, she is also the head of a socio-political organization funded by large benefactors, including her partner Bezra. Your Excellencies, we submit that teachers possess a level of authority that can influence and incite not only the students, but also other citizens to participate in activities that can disrupt public peace and order. While teachers have the right to academic freedom as professors, they are, however, held to a higher standard with respect to their conduct inside the classroom, as well as during off-duty activities. This has been observed by the Human Rights Committee in the 2000 case of Malcolm Ross versus Canada, where the committee upheld the suspension of a professor who published controversial works expressing religious opinions. In that case, Your Excellencies, the committee held that the teacher's influence justifies restraints in their exercise of freedom of expression. And here, Your Excellencies, while the applicant claims that Professor Shikra's post was merely an encouragement, we, however, submit that given her status, her statements, if not made responsibly, can be easily taken out of proportion by not just her students, but also by anyone who acknowledges her influence. Your Excellencies, if we may respectfully direct you to paragraph 16 of the clarifications. We can see that the applicant's statement was immediately followed, wherein members of a student organization boycotted classes the next day. Here, the applicant claimed that there was no reasonable connection between the boycott and Professor Shikra's post. We respectfully disagree. This is because in paragraph 39 of the record, Sanok, or the student organization's statement, expressly referenced on Professor Shikra's post, wherein they endorsed Professor Shikra's call for action. Your Excellencies, on that note, while we do note the actual effects of Professor Shikra's statement, we, however, emphasize that incitement is an inchoate offense. And thus, the fact that Professor Shikra's statement was immediately followed only shows that there was a reasonable probability of harm, or that repeated statements in the future would produce an elevated harm. And this brings us precisely to the second level of our analysis, on the context of the statement and its likelihood to harm. Here, Your Excellencies, the respondent is aware that the gravity of the issue on education is currently escalating. And thus, while the respondent encourages and appreciates the participation of the citizens in discussions on matters of public interest, We, however, emphasize that as stated by the European Court of Human Rights in the 2000 case of Le Pen versus France, that even in the context of a political debate or a debate on a matter of public interest, speech or freedom of expression may be validly restricted if it involves incitement to violence, discrimination, and hostility. Here, Your Excellencies, if we may respectfully direct you again to paragraph 37 of the record, the applicant's statement did not only call for a simple student boycott. She called for three things, including the occupation of all university premises and non-tolerance to traitors to the cause. Worse, Your Excellencies, she urged both students and academics to undertake these three activities indefinitely or until change comes. Your Excellencies, we have seen in Brazil in 2013 what the two latter activities with which Professor Xicra called for would look like. We thus submit that with the language used by Professor Xicra in calling for occupation of all university premises, this implied barricading the gates of the university, squatting in classrooms and offices, and therefore depriving the use of such facilities for educational purposes. This would be an interference on the right to education, which is protected in Curulu's constitution and in ICSCR. Furthermore, Your Excellencies, the call not to tolerate traitors to the cause is essentially a call to discriminate or be hostile against those who do not support Xicra's campaign. Your Excellencies, this could lead to bullying inside or outside the classroom, or worse, actual injury or crime towards those who do not support Xicra's campaign. We thus submit, Your Excellencies, that if we may paint a picture, given the situation in Curulu and the gravity of the issue on education, as well as the likelihood of violence, wherein in paragraph 34 of the record, there was already an incident of violence during a student protest. We submit that repeated statements calling for an indefinite total strike action will result to not only a serious disruption of public peace and order, but a total condemnation of the current educational system to a point of no repair. The respondent cannot allow this, Your Excellencies, and thus we submit that it is within the protective function of the state to regulate acts that would make the crisis in Curulu worse. Turning now to proportionality, Your Excellencies, we submit that the restriction imposed on the applicant is proportionate as it employed the least intrusive means necessary to achieve the legitimate aims. Here, Your Excellencies, we emphasize that in General Comment 34, a proportionate measure is not only the least intrusive means, rather it is the least intrusive means that can achieve the legitimate aims. And thus, in the present case, the 1 week suspension with an additional undertaking or with an undertaking for the lifting of such suspension is justified as such sufficiently addresses the harm sought to be prevented.
Mr. Albert, is it your submission that every element of the statement at paragraph 37 of the facts of the case is problematic from your point of view? Does it make a difference if the statement had simply said refuse to teach or attend classes and hadn't said anything else? Would that have been protected by freedom of speech, and would it have been appropriate for the university to say that that calls for disruption?
Your Excellencies, while we do note that a mere call to boycott or the mere call to refuse to teach or attend classes would amount to or would be a valid call for boycott or valid call for protest. We, however, submit that Professor Xicra's statement here should be taken as a whole or all together, and thus the fact that she urged both students and academics to undertake these three things indefinitely amounts to an incitement to violence, discrimination, and hostility. Here, Your Excellency.
Sorry, I didn't mean to interrupt. But the reason I asked the question is that the conditionality imposed upon Professor Xicra was that she should refuse to make similar statements in future. Now, it's not clear to me what similar statements are. What are your submissions in that regard? Is it exactly the same statement, or would it be a similar statement just to take one element of this consolidated statement that was posted on the 9th of July?
Certainly, Your Excellencies. Allow me to guide you on that concern. If we may respectfully direct you to paragraph 60 of the record, we submit that the term similar statements in the condition refers to the three things that the applicant called for in the present case. The panel, in recommending the disciplinary action, cited these 3 reasons in its determination, and therefore, contrary to the applicant's submission, Your Excellencies, the applicant here is not being prohibited from expressing her opinions or her views on the privatization of education. Rather, what she is asked to do is to act more responsibly and not call for statements that would disrupt the normal operations of the university and would lead to incitement to disrupt public order and interfere on the right to education of others. If that sufficiently addresses Your Excellent Madam President's concern.
Well, it does seem to me to be a question of whether this sanction imposed upon Professor Shikra was proportionate or not. Depends on our understanding what, in fact, the sanction prohibited her from doing in future. So it seems to me that it could well be argued that, in fact, it needed to be much clearer that this prohibition or this sanction is rather formulated in vague terms, which would chill her freedom of expression, possibly quite improperly, beyond what Article 24 requires.
Your Excellencies, we respectfully disagree. While we do understand that the condition here would, rather, we respectfully disagree that such condition is vague. As seen in paragraph 60 of the record, it is quite clear, and thus the term similar statements here refers to activities that would disrupt the normal operations of the university. Here, Your Excellencies, we submit that the restriction imposed on the applicant is proportionate as it sufficiently addresses the harm sought to be prevented. Here, Your Excellencies, we emphasize the applicant here did not only violate the code of conduct, her statement also operated as incitement to disrupt public order and interfere on the right to education, which could result to lasting effects for her followers, not only her students, but also other citizens of the state. Your Excellencies, if that sufficiently addresses your concern.
Well, you may proceed.
Thank you, Madam President. Turning now to the first part of the test, we respectfully submit that the restriction is provided by law. Your Excellencies, here the applicant claimed that the Code of Conduct should provide the definition of disciplinary action and list an exhaustive list of instances of gross misconduct. We respectfully disagree. Your Excellencies, the standard for foreseeability under General Comment 34 is not absolute certainty, but only sufficient precision. Here, Your Excellencies, in paragraph 42 of the record, Section 24, paragraph 4 of the Code of Conduct sufficiently describe what conduct results to disciplinary action. Also, Your Excellencies, to address the applicant's claim that there is a total ban or ultimate ban on strike action, we respectfully disagree. On this note, we emphasize that Article 8 of ICE-SCR and Art 21 of the ICCPR on right to strike and right to peaceful assembly are not absolute rights and can be validly restricted for legitimate reasons. This is what happened in the present case. Your Excellencies, if there are no further need for my assistance, I see that my time is up. That concludes my section.
Thank you very much, Ms. Arbo. We're grateful to you.
Thank you, Madam President, Your Excellencies, and may it please the court.
We will now call on the applicants for their rebuttal, for which they have 3 minutes.
Thank you, Your Excellency. For rebuttal, I will deal with the first ground first, under which I have 2 points. Firstly, my honourable friend for the state referred to Kerala having existing legislative measures. Simply, they do not. The only current legislative measure in Kerala is Bataja from 2016, which deals with social media harms. The true test is what is the quality of the law, as per Cruzet and France from the European Court of Human Rights. The law needs to be sufficiently precise so people can regulate their conduct. That is simply not the case of Bataja, so quite frankly, the state is failing. Secondly, my honourable friend said that Khadija Isma and Azerbaijan from 2019 was wrongly applied. This is not the case. From that case, it is clear that leads need to be pursued via an effective needs. And secondly, the fact that the police applied for the warrant is not enough. The state has to provide the remedy, and state decisions include judicial as well as government, which the respondents neglected to mention within their submissions. Moving on then to the second ground of this.
Recording in progress.
Moving on then to the second ground, on this I have 4 submissions, all of which are to do with the question of necessity and immediacy. Firstly, I'd like to draw attention to the Honourable Court that it is the burden of the state to prove all three conditions are met. My honourable friend for the state has not done that. She has only touched on the question of necessity and proportionality, briefly on law, but not answered our questions regarding the fact that the law leads for wide discretion, and did not establish the legitimate aim. So with that in mind, I will move on to my rebuttals onto the question of necessity and proportionality. I asked our honourable friends if they could show why there is a clear and immediate link. They have been unable to do this. They have spoken of the fact of the Stanek post and these being inevitably linked, but this is quite frankly not the case. They've also stressed how important the position of teachers is, and to do this, they drew on the case of Malcolm Ross in Canada. It is our submission that they have misapplied this case. Malcolm Ross in Canada is to do with school teachers. Undoubtedly, it's clear the influence of school teachers could have on school students, simply because they are younger. The university environment is a complete different environment from the school. The university environment dealing with students that are undoubtedly older and where the university mission is to impart freedom of speech. Therefore, it is the university's job to guarantee freedom of speech. Indeed, in democracy, freedom of speech is the backbone of it. The restrictions which the state have put forth threaten it, and we urge the Honourable Court today to protect freedom of speech as worldwide it is being threatened. Thank you, Your Excellencies.
Thank you very much, Ms. Farrell. And now we will turn to the respondents for their rebuttal. So rebuttal. Mr. Santamaria.
Madam President, Your Excellencies, the applicants make several points in their rebuttal, which we now address by way of rebuttal. First, Your Excellencies, the applicants cannot continue to insist that Batiksha here is ineffective. We do agree with the applicants that the quality of law is what we must be examining when it comes to assessing the effectiveness of a measure. And we submit, Your Excellencies, that this standard has been met by the Batiksha ruling. By requiring only reasonable steps for social media platforms, it already affords flexibility that accounts for the different capabilities of different platforms. The second point that they make, Your Excellencies, is that we have misunderstood the Ismailova versus Azerbaijan ruling. We submit, Your Excellencies, that we have not misapplied this case, but rather we have correctly invoked the standard there that is one of due diligence. And this has been sufficiently complied with by the state in the present case. Moreover, the applicants have still not been able to demonstrate how the issuance of a warrant would be justified here, especially since it breaches anonymous expression. The next points that the applicants make concerns the suspension of Swarna Shikra from the National University of Karulu. They claim, Your Excellencies, that we have not been able to establish the legitimate aim, and we take the opportunity to do so now. The legitimate aim that the state is pursuing here is the protection of the rights of others, specifically the right to education. Swarna Shikra's post had the potential to disrupt the normal operations of the university and had the potential to disturb and harm this particular right. Moreover, Your Excellencies, we also note that another legitimate aim that the state is pursuing is the protection of public order. Again, Swarna Shikra's post had the potential to cause unmitigated damage to the National University of Karulu as well as other universities' premises. Given this, Your Excellencies, we submit that there is indeed a legitimate aim being pursued. Lastly, the applicants continue to insist that we have not established a clear and immediate link between Swarna Shikra's expression as well as the supposed harm that it can cause. However, Your Excellencies, we disagree, as the facts clearly show that Karulu was in a state of immense public disorder, where anything that Swarna Shikra could have done would have only added fuel to the flame. She knew that the issue of public education in Karulu was one that was close to many and anything that she could have said would have disrupted this delicate balance of order. Given this, Your Excellencies, we submit that the suspension of Swarna Shikra from the National University of Karulu, as well as the imposition of conditions, remains necessary and proportionate in the present case. Now, Your Excellencies, unless I may be of further assistance to this honorable court, that concludes our rebuttal. I thank you all for your time and indulgence. It has been a privilege to appear before you today. May it please this honorable court.
Thank you, Mr. Santamaria, and thank you to all the council for their submissions. At this stage, the panel will adjourn to deliberate on the matter, and we will rejoin you in a little while. Thank you.
To turn on their cameras. The judges are back and ready to deliver feedback. If we can wait just a couple of seconds for the second team to turn on the camera so we are sure they are in the room with us. Okay, that's perfect. Judges, the floor is yours. Thank you.
Thank you very much, Nevena. We're going to start by a little bit of feedback to the final teams. We all enjoyed your presentations enormously, and I'm going to turn to Judge Stevens to make the first comments on and feedback to you on your arguments. Mark.
Thank you very much, Madam President. Kieran, I thought that your start was fabulous. The way you laid the table was a really lovely style, incredibly well structured. I found it easy to follow. I think some of the questioning from me was expectedly hostile and was intended to throw you off your game, and you soldiered on well. So congratulations. Caitlin, I thought your introduction was very good. You were excellent on the burden, and I thought your pickup of the hole in the memorial for the other side was good, because it had me running to the memorial and having a look at it, and clearly that was good. It was good, strong language. You gave good answers to questions, and I thought you'd obviously anticipated the question from President O'Regan in relation to the university and the employment, and that was a very clear, concise answer. And I think the preparation of anticipated questions was very good from that. I think that you did good time management, and I thought that your sum up was excellent. Turning to Brian Santamaria, again, very good introduction, good citations, and your closing was really good. It was excellent on time management. I mean, you were literally to the second. And I thought your rebuttal was very clear, concise, and much more on point than I'm used to in the Price Moot. So well done to you for that. Meg, I thought your setting out of the tests and the facts and applying them was excellent, and I really enjoyed your oral styles. And what's important about this is that your styles were all very different, but actually incredibly effective as a judge in listening to them, and I found them exceptionally easy to follow. So thank you very much for the obvious hard work and effort that you have all put into that, and obviously those that have worked with you. Back to you, Judge O'Regan.
Thanks very much, Mark. And now going to turn to Judge Reventlow.
Thank you very much. Well, thanks to all the oralists for doing a wonderful job. It really was a pleasure listening to you. I have to echo many of the things that Mark just said. Kieran was really well done. Caitlin, I particularly admired the way in which you managed to respond to questions and then tie it back to the original arguments that you wanted to make, which is a really wonderful thing to be able to do, to kind of like keep on track on the things that you actually want to bring across while the time that you have to speak before the court. So really good, really good job there. A bit more fiery. I really enjoyed that as well. Yeah, it was a very engaging style that you have. Brian, very engaging in a different way, very calm, very collective, very, again, like really amazing time management. I wish I were that good. The close was really great. You even managed to do a close in rebuttal, which I find even more impressive. Yeah, super well done. And for Meg, also very steady, very calm way of answering questions, also excellent time management. So it just felt very much like you had everything under control. And that kind of like goes for both teams, though they're very different styles. You both, yeah, gave a really good impression of being in charge of both the material, of the substance, and really able to pivot around the questions that were asked by the court. So a really great job.
Thanks, Nani. So I echo everything that Mark and Nani have said about your presentations. It was a pleasure to listen to all of you. Very interesting to see the different styles. I thought all of you provided a very clear signpost as to where you were going in your argument. You stuck to what you said you were going to do. That's always extremely helpful to judges to know where you're going. And I thought all of you did a good job of answering the questions without being too distracted from your overall argument, which can sometimes be very difficult, and work out how much detail to give in your answers. And I think it did show, I agree with Mark, that it showed that you've done quite a lot of preparation. And of course, by this stage, you've answered a lot of questions along the way. So I'm sure you got used to it, but it showed in your presentation. So thank you to all of you, and congratulations to all of you on excellent work. It now falls to me to announce our decision. And the first decision we're going to talk about is the overall winning team for the Moot. This was a difficult decision. It often is when you get to the finals, because by this stage you have had a lot of experience and excellent teams tend to come forward. But I think that despite having found it difficult, the panel was eventually unanimous that we thought that the respondents, Team 707, were the winners of this year's Prize Moot. So warm congratulations to them, but that's not to say that our runners-up weren't absolutely outstanding as well. Turning then to the winning oralist, here we had distinct difficulty. There were arguments in favor of all 4 oralists, and having debated back and forth between ourselves, we decided that the only way forward was actually to split the prize between 2 of the oralists. What was interesting about these 2 oralists is they had very different styles, but we thought that both of them were extremely effective in their styles. And those 2, the winning oralists then are Caitlin Farrell and Brian Santamaria. So one from each team. And it's not to say that the other 2 oralists weren't candidates for this award. They would have been if we had more. They were all excellent in the views of the panel. So congratulations to you all. Thank you for affording us a very entertaining hour and a half. We've really enjoyed listening to you. And congratulations to your coaches and to the teams. We know that a team has got a whole panel of people behind them, and we think that in both cases here, the support work done for these 2 teams must have been outstanding. So congratulations to them. Nevena, would you like me to move on from here, or shall I hand over back to you?
I just want to use this opportunity to thank both finalist teams and to congratulate to both teams and to reveal the universities. So the winner of the 16th international round is the team 707, University of Philippines. Congratulations. And the runner-up is team 108, that's City University of London from UK. So congratulations to both teams, both oralists. It's a tie. And I would just like to remind you that in an hour, we will have an award ceremony with other awards that we will be giving out. But before that, I would just like to ask Kate O'Regan once more to say a couple of words from the Bonavero Institute. There is the home institution for our Moot, since she won't be able to be with us in an hour. So Kate, please.
Thank you very much, Nevena. And just to say that the Price Media Moot is a cherished program at the Bonavero Institute. It's cherished not only because it displays, student excellence from around the world. We're delighted to run the Price Media Moot in 8 regions of the world, and seeing the quality of the students that are emerging across all those regions is enormously inspiring to all of us. But it's also because it addresses an issue which is close to the heart of all of us, and which we all realize is central to the project of human rights, the rule of law, and democracy around the globe. And that is the question of freedom of expression and the media. And so we believe in this Moot because we believe that the media are a very important element of any democratic environment, and that deepening knowledge and engagement with the international human rights law principles that relate to freedom of the media, freedom of expression, Article 19 of the International Covenant of Civil and Political Rights should be one of our core missions. The Price Media Moot does all of those things. In bringing the Moot to life every year, there is an enormous amount of work, some of it behind the scenes and some of it not so behind the scenes. And I would like to thank here the extraordinary team that does this every year, led in the first place by Nevena Krivokapic-Martineau, who has been a leader of this Moot now for, I think, probably 7 or 8 years, and who is extraordinary. She puts so much energy, passion, dedication, and humor into this exercise that it makes it an enormous amount of fun for everybody who in her and the team. But the rest of the members of the team are equally fantastic. There is Sarah Norman, who is our programs administrator at the Bonavero, who is, again, an extraordinarily dedicated but fun human being to work with. It's wonderful to have you as part of this team, Sarah. Sarah has been freezing today because it's lovely and sunny in Oxford, but actually is 3 or 4 degrees outside. Sarah thinks about the Moot every day of the year and does an enormous job in making sure that the Moot stays on track. So we're really fortunate to have her to work with, but very grateful to her for all she does. And then there's Camille Adair Morgan and Sanya Samtani, and this year Juliana Murtok, all of whom are core members of the Moot team. I have to say that if you could have half the spirit of this team in any other team you worked in, it would be a success. They really bring both passion and engagement and a sense of fun to the task, even though they are now spread thinly over the world. So very grateful to them for all the work they've done. But in addition to the team that supports at the Bonavero, there are regional teams in all our regions. There are partners, institutions in all the regions, and they are absolutely core to the success of this Moot. Every mooting team here in the Bonavero, or nearly all of them, start out in regional rounds. Those regional rounds are an enormous exercise to pull off, and they're pulled off in regions across the world every year. As you all know, those have often been online since the COVID crisis in 2020. We're still hoping very firmly that we will be able to be back in person in the near future. But the regional rounds and the leaders of the regional rounds have remained dedicated to the task all the way through these difficult years. And then, of course, there are the mooters themselves, the coaches, and the members of the team who are amazing. And who have, as we have seen in this final round, producing really high quality advocacy in what are still their student years. One does wonder how high they will fly when they leave university. And my final thanks today is to the person who writes the Moot, Gahan Gunatilaka, Dr. Gahan Gunatilaka, who is a research fellow here in the University of Oxford, working in the field of freedom of religion, but also freedom of speech, and is himself a former journalist, has been the author of the Moot problem now, working in collaboration with the broader team, but very much the author of the Moot problem for many years. And he puts an enormous amount of thought into each Moot problem. And I think we see the value of his enormous knowledge of international human rights law in the way he designs the Moot, but also his engaging adoption of some of the most contemporary issues of the day. In this year's Moot, questions of academic freedom, which are live in many jurisdictions around the world, but also questions of the regulation of social media and the duty of the state to regulate social media. So those were two of the kind of key problems this year. I can tell you he's already thinking about next year's, and next year's is going to be an equally engaging and important contemporary problem. So keep an eye out for the publication of the new Moot topic. In the meanwhile, then, it's just thanks from me to all of those people. Congratulations again to the winning teams, but to all the teams who participated in these final rounds. Getting to these final rounds is an enormous achievement in itself, and to all the teams who participated in the regional rounds. We very much look forward to welcoming you back next year. Fingers crossed it might be in Oxford in the final rounds. We can't be sure yet, but we hope so. And thanks very much and farewell. Oh, yes. I should indeed also mention, thank you, Mark, I should also mention our wonderful eponymous Monroe Price, after whom this moot is made and who has been such a great partner to the moot all along, and who believes so strongly in the importance of students engaging with these complex contested issues. Monroe is here today in the background. It might be quite nice, Monroe, if you could turn your camera on. We are enormously proud to be associated with Monroe Price in this moot, who himself has a distinguished career as an advocate for media freedom and engaging with media freedom across the world, and who is passionate about the moot. Monroe, are you going to give us a little vision of yourself, or are you not? I think Monroe will appear at the final award ceremony later if he's not here now.
Yeah, the camera for Monroe is on, but he's not there as far as I can see.
Okay, all right. Well, thanks everybody, and congratulations once again, and look forward to seeing you all in due course, hopefully in Oxford.
Thank
Over
you.
to you, Nevena.
Thank you so much, Kate. After everything that Kate said, I would just like to thank once more Nani Jansen-Reventlow and Mark Stevens, and Kate, of course, for being here as a final bench judges. We really do appreciate all the support that all of you has been giving us throughout the years, even in last 10 to 15 years. So thank you so much. And teams and the others, see you in 45 minutes for the award ceremony. Thank you all.
Thank you.
I'm appearing to say thank you. Thank you.
Thank you, Monroe. That's great. Lovely to see you. And we were just saying nice things about you and how wonderful it is to have you.
I heard every word, and I was trying to repeat the wonderful words, attribute them to the work that you and the team are doing, which is quite extraordinary. Thank you.
Thanks, Monroe. Take care, everyone. Bye.
Bye.
Bye.